All right, well, good afternoon, everybody, and a very warm welcome to all of you who are joining us online today. We've got people dialing in from across the state, so thank you so much for being here. From Brisbane, I acknowledge the traditional owners of the land on which we're facilitating this webinar, the Turrbal and Yagara peoples. I'd like to pay my respects to elders past and present, and I especially welcome and pay respect to all First Nations people who are joining us online today. I just would like to note that our slides that we'll be sharing do have photos of First Nations people that were taken during the course of this project, and we do have permission to use and to share those. Please let us know where you're dialing in from by using the chat function. It's always a really lovely gesture to get that sense of geography and that connection to country, that vast connection to country across Queensland. And to remember that even when we're meeting here online, we're doing that on land that was stolen and sovereignty was never ceded. My name is Monica Taylor. I'm facilitating and co-presenting this event that we have this afternoon. We are so delighted to have the Queensland Human Rights Commissioner Scott McDougall joining us, and he will be sharing his reflections on the work of frontline staff to embrace human rights decision making and how human rights can improve outcomes for social housing tenants and people experiencing homelessness. Scott is the inaugural Queensland Human Rights Commissioner, and he's had the formidable job of overseeing the implementation of our new legislation in times that none of us were really able to foresee during the COVID-19 pandemic. Scott's work will be familiar to many in the audience, but for those who do not know Scott, he has a long-standing commitment to justice and has worked for decades using the law to improve the lives of Queenslanders. QCOSS is really grateful for Scott's support and the support of the Queensland Human Rights Commission throughout this project. And I do want to note the sort of talented staff at the Commission, Rebecca Leong, Celia Wigsell and Heather Corkle, who have been really supportive as we've gone through. All right, so today's session looks a little bit like this. We are going to present first for you the project journey, tell you what we did and how we went about doing that. And my colleague Sally Foe will take the reins for that part of the presentation. Then we will hand over to Scott, who will deliver some of his thoughts and reflections. This project has been done in partnership with the Department of Communities, Housing and Digital Economy, and I do want to pay my respect and shout out to our colleagues at the department. Once we've heard from Scott, we'll have time for question and answers, and we really encourage people to use the chat function to share thoughts as the information kind of comes across to you. Even though this was a project that is grounded in housing and homelessness service delivery, what we did, the resources that were created and the findings and learnings that we've kind of gained have broad relevance across different sectors in the care economy. All right, so I'm going to hand it over now to Sally.
Thanks, Monica. I appreciate the introduction. Welcome to everybody here today. Before we explain all our findings from the project to you, I'll quickly run you through the journey that we've been on over the last 12 to 18 months, 12 months of delivery. It looks very much like you see it in the pictures. There was a lot of discussions, we had a lot of meetings, there was a lot of training, there was a lot of webinars. We've got Michael again here today behind the scenes making it all happen. So we appreciate everyone's involvement. As Monica stated, the project aimed to work alongside housing and homelessness services and social services more broadly to develop human rights knowledge, capability and confidence using the Act. We approached this work with a view to better understand how the Human Rights Act is being implemented into services so we could create resources resources that are useful and support frontline staff to really use the Act to improve the lives of people who access our services. The learnings we've gathered and the resources that we have created are an outcome of a great partnership. And we thank each and every person involved. We thank the other peak bodies and expert stakeholders for sharing their experience, especially during the initial project setup phase. So thank you to the stakeholders for popping them in the chat just to save a little bit of time. We would also especially like to thank those people that accessed one-on-one support with us, and also those people that were human rights champions with the project and the work that we did with them. So a core part of our work was done with champions and with participants of our community practice. Let's have a look at some of the activities that we undertook. Okay, so our champions were within the Department of Housing and Department of Communities, Housing and Digital Economy, and they were also 5 community organisations that were located around the state. We're really, really impressed and pleased with the interest we had in people joining us on this journey to be champions, and we were really grateful to be able to work with such a diverse group of organisations. So we had very large organisations, very small organisations. They came from different geographical areas around the state. Some of the organisations delivered their services locally, while others actually delivered over a really vast geographical area. We had organisations that had different governance structures, so that gave us some real insight into the real diversity of how community organisations are operating and how we can use the Act within those organisations to deliver services. The other thing we're really proud of in the selection and the working with these organisations is that we had organisations delivering homelessness support, outreach support, providing crisis accommodation, shelter accommodation, and organisations delivering social housing. So we really got organisations that delivered the vast range of housing and homelessness services involved, and we got to see their insights and work really closely with them. We're really lucky, as with many community organisations, they don't just deliver housing and homelessness services, they deliver other services like family supports, health services, financial counselling, so that we got to see some insights with that as well. So let's have a look at what we did. Next slide, thank you. So we did a range of activities through the course of the 12 months. We hosted 6 webinars, this being our final one. Webinars covered a range of topics, so from proper consideration and the complaints mechanism within the Act, and we explored also other topics like how human rights plays a role in advocacy and social inclusion. If you're wanting to catch up with those things, because if you're new to the project, they're available with the resources online in our video resources. Much of the work that we did was with training. So we ran 31 training activities around the state. Much of this was face-to-face, and we were really lucky and really pleased that we were able to navigate around the many COVID restrictions and still get face-to-face with people. We found that the engagement face-to-face was so much better for this particular topic. We found that participants were far more engaged, and we also had the content, but also the informal discussions where we could really unpack how the human rights is looking in their day-to-day decision-making and in the work that they're doing to make the training really, really relevant. We're really pleased that throughout those training series, the series of training, we've been developing a workbook, which we iterated throughout each of the training activities, and the workbook resource is a culmination of all of those training activities. So thank you guys who road tested them for us. We also provided one-on-one support. The one-on-one support wasn't utilised as much as we were hoping, but it has been a really busy year with everyone having so much demand for services this year. The one-on-one support activity is was just so important to the delivery of this project and the relevancy of the resources that we've created. It really allowed us to unpack a range of scenarios alongside our colleagues providing services. Some of them, there was a clear path to move forward. Others were really complex and quite technical. So we really appreciate and it gave us great insight. And anyone setting up a similar project would really encourage people to offer that support moving forward, because the benefit to both the project and the participants is paramount. Just being able to unpack a complex situation and being able to provide guidance and some reassurance in how to move forward was really paramount. And the last not so interactive activity, but very important still, was reading policies and procedures and providing feedback. With our champion organisations that we worked with, we actually reviewed 58 policies and procedures. Some of these policies were very operational, so around property allocation, debt management, those kinds of operational decisions, but there were also policies around an organisation's operating. So, you know, the accessibility to the organisation, the asset management of properties, you know, there was a whole range of things that the Human Rights Act did play a role in. And so it did mean that there was a lot of reading, of which we are grateful for. So with all of that intelligence that we gathered, we produced some resources that will withstand the end of the project and hopefully be of great benefit to you guys, at least a little benefit for you guys. We won't dwell on this slide very long. All of these resources are available on Community Door. And I think we'll just paste that link into the chat if you're not sure where that one is. The resources are really aimed for frontline staff as well as sort of managers and policymakers. Resources can be used as self-service, or you can incorporate some of these material into other training activities that you're doing. They showcase how human rights consideration can support service delivery decisions, and they can demonstrate how organisations are providing human rights aligned outcomes for people. So check out those case studies. They're in the case study library. They're really co-designed. They were real scenarios that we worked with, and yeah, we're really, it will really provide some benefit. We used it a lot in training. The other sort of product in here that we co-designed were the operational tools. There is just a general tool for helping support human rights consideration, but there are also two bespoke tools. The delivery of housing is very complex, and there's two really key points in the delivery of housing: the allocation of property and giving consideration when there's a tenancy at risk. And there's two bespoke tools that we've designed to help support staff with those decisions. So feel free to incorporate those tools into your procedure, like some of our champions have done, or use them as a bespoke standalone resource when you need it. It's really up to you. Next slide, thanks, Michael. Yep. We, as many of you know, we measured and listened regularly throughout the project, hearing how all information we were delivering would improve outcomes for people. It was really great hearing about the change, especially those changes that were outward focused, supporting conversation between other service agencies. But we also heard about changes that were inward facing, organisations that were reflecting on their own practices. Those that gained the most benefit from the work that we were doing really did both of those things. They started by being quite reflective and looking at how the Human Rights Act applied to their own work and understanding their obligations. And then they were able, through that understanding, to actually use their knowledge outwardly to help with their collaboration and advocacy work. That's where we saw some real benefits and saw the organisations really making that cultural change. We also thank you everyone for measuring your confidence throughout the project, and we saw a really great increase in confidence throughout the project, which we'd like to claim all credit for, but really it was us. It's the work the Commission continues to do to support the sector in understanding, and organisations themselves also doing work to support understanding of human rights. With over 1,200 people engaging with the project over the 12 months we've been live and active, the materials, engaging with the materials with a range of sectors. The majority of the participants have, of course, been from housing and homelessness. Thank goodness, because we were trying to target them and provide services for them. But there was really great diversity. People recognised that a lot of this material was relevant to other services and industries, particularly other community service agencies. Well, thank you for listening to our quick wrap up of what we've been doing the last year. I'm going to hand it back to Monica now, who's going to present some of the findings that we've had during the project. Thank you.
Thanks very much, Sally. And just bear with us, audience. I know that we are the support act, but we'll just go through some of these findings before everybody has the privilege of hearing from the Commissioner. So we found a range of things. I just want to talk first about the real need for specific knowledge of the legislation itself. Our sector is absolutely full of people who have an abiding commitment to social justice and to human rights principles. But that doesn't necessarily presume the ability to understand what's required in the legislation itself. So we found that even though people have that kind of intrinsic values framework, people still really needed to know the specifics. And that was about getting your head around the actual 23 rights that are contained in the legislation. That doesn't require memorisation, but it does really require a working knowledge of those rights. Understanding what organisations are and are not public entities. That did throw and continues to throw, I think, all of us off, depending on the situation and the organisation delivering services. Understanding the complaints process that we have in the legislation and timeframes and the internal complaint requirement before a complaint can go to the Commission. But most importantly was the proper consideration requirement and giving proper consideration to human rights. So this was fundamental. We found that it was really about practice and repetition, using case studies and examples time and again, made that come more sort of naturally to people in their decision making. Connected to that, of course, is the sheer amount of decisions that people actually make on the front line in a day-to-day basis. Identifying those decision points is trickier than I think we realise, and there is just so many, and not just decisions that in legal terms are administrative decisions that can be reviewed, but we live with the ability to give discretion through our work in so many ways, and it was those sort of lesser discretionary decisions that could sometimes trip people up. Another key finding was the need for a cultural change and the need to really sort of approach implementation of the Human Rights Act as a broader change piece, not just narrow procedural compliance. And so organisations that were really good at doing this had leaders who led by example and were really able to admit when they had made a mistake or overlooked, a step in the chain of giving proper consideration. I remember, one training session, and it was a round table, and the CEO of that organisation was very candid in admitting that a decision that they had made that day overlooked some significant human rights, but it was done in such a way that all of the staff around the table felt they had permission to also admit that they made a mistake. And I think that kind of safe space to get on board with the legislation is just so terrific, and that's what will take us forward to the broader cultural change piece. Another key finding through this project was the real benefit of the human rights legislation supporting service collaboration. And as anybody who works in housing and homelessness knows, that the interaction of those services with other social services is inevitable. So working alongside mental health supports, hospital discharge, local councils, police and aged care really requires an intersectional approach. And so we think that there's a lot of capacity there for the human rights legislation to continue to support service collaboration. Also on that point, we did hear a lot about people talking about the very varied practice frameworks that are used, so trauma-informed practice, person-centred delivery of services, and a human rights framework. And often there was some tendency to conflate them as all one and the same. So one thing that I think is useful for people to understand in their workplaces is that the human rights legislation provides a legal obligation that sits alongside other practice frameworks as well. Now, those were really the key findings. There are more observations that we could make, but keeping to time, I want to really now hand over to the Commissioner Scott McDougall to offer his thoughts and reflections. Thanks, Scott.
Thanks very much, Monica and Sally, for the introduction. And thank you to QCOSS and to the department for putting together and implementing such a fantastic project that really shows the value of the Human Rights Act already. In other state jurisdictions, in Victoria and the ACT, we've seen similar sort of progress, but I think Queensland is well ahead of those other jurisdictions in terms of what we've been able to achieve in really a short period of time. So I just wanted to congratulate QCOSS for their leadership in developing this project, and of course acknowledge the traditional owners of the country that we're all on today. I'm looking out over a still sort of brown and quite angry Brisbane River. Belongs to the Yagara and Turrbal people of Brisbane. And I pay my respect to the elders past, present and emerging. So today I wanted to talk about a couple of the challenges that we face in implementing the Human Rights Act in the housing sector in Queensland, and talk about some of the broader context, but also an example of a successful outcome that I think, again, shows the value of the Act. And I guess one of the big challenges that you probably no doubt hear is that the Human Rights Act in Queensland has not actually protected a right to housing per se. So the right to housing is acknowledged in the Universal Declaration of Human Rights that was signed in 1948. But that right has not been specifically protected in Queensland's laws. And often I hear that is an impediment, but that doesn't mean, and I'm sure if you've learnt in the course of this project, that the right isn't indirectly protected through the protection of other rights. And also, I wanted to highlight the Human Rights Act specifically says that nothing in the Human Rights Act actually takes away from any other right that is protected in international law. And it specifically notes the Universal Declaration of Human Rights in that provision. So it's important to remember that the right to housing does exist, to adequate housing, I should say, does exist in international law. And just because we have a Human Rights Act that protects in law certain limited rights doesn't mean that that right to housing isn't relevant in Australia. And you should continue to advocate for that in your general advocacy. So in terms of the rights, specific rights that are protected under the Act, that I'm sure no doubt came up during the course of this project. I thought I'd mention just a few of them. So Section 15, the right to equality and equal recognition before the law, is essentially a general guarantee of protection against discrimination. And I'm sure that you're well aware of the discrimination that exists in the housing sector that presents such a huge barrier to many people on various grounds. Obviously, race and disability are two of those grounds, but there are other grounds such as socioeconomic status that, whilst are not protected in Queensland's other laws, such as the Anti-Discrimination Act, arguably are protected again in international law. The right to privacy and reputation in Section 25, I saw in one of the fantastic videos that was presented as part of this project. And by the way, that video was just fantastic for me to watch, and to see the Human Rights Act being rolled out and implemented and discussed right across Queensland and in places like Mount Isa, just really brought a big smile to my face to see it actually happening, because having worked on the Human Rights campaign with Amy, the realisation of rights being recognised and worked on a day-to-day organisational basis is just really exciting to actually see happen, and to move from an academic idea to something that is actually on the ground in reality happening is just really exciting for me. So privacy and reputation is a very, very broad right, and really extends to the psychological integrity of individuals who are affected by decision making. So I think that is one to really keep an eye out for. International law on the right to privacy is continuously developing. So essentially it boils down to the individual's integrity, but also obviously their right to protect their home. Section 26, the protection of families and children, again, a fundamental right in the Human Rights Act with broad application. So decision makers needing to actually consider what is going on for the child occupants of tenancies is a critical issue here. And in my prior life, before coming to the Commission, I was the director at Caxton Legal Service. We had a number of cases where women who were victims of domestic violence were being evicted from tenancies, and on some occasions because of criminal convictions, on other occasions just because of the disturbance to neighbours. And it was really apparent to me in the course of those cases that the rights of the children who were occupying those houses just was not being considered. I just remember vividly one case where there was a child who was finishing their grade 12 studies, and their family was being evicted from the premises, and just the impact that would have on that child. And I think in that case we were able to prevent the eviction, but the impact that would have had on that child would have been absolutely profound. And then another right that I think is highly relevant to the work that you do is Aboriginal and Torres Strait Islander cultural rights in Section 28. And I think, as Monica expressed again in that video, this is conceptualized in broader terms than other jurisdictions. And I'm really keen to see Aboriginal and Torres Strait Islander groups advocate and indeed litigate under this right to really develop the jurisprudence and the laws and strengthen the meaning and application of this right, because I think it potentially has really broad implications for Aboriginal housing, not just in the number of houses that are made available to Indigenous people, but also the design of the housing and ensuring that it is designed with cultural factors at the heart of the design. So again, that is a really interesting issue. And I remember doing a trip to Alice Springs probably about 8 years ago and talking to a housing provider in Alice Springs a lawyer in Alice Springs who was lamenting the fact that families who were vacating their houses for short periods to conduct sorry business in remote communities were being subjected to eviction notices, and the housing providers not taking any notice of those cultural needs. And so, yeah, I remember at the time thinking that similar things would no doubt be happening in Queensland, and that the current laws in Queensland at that time would not have protected those residents either. So again, I think cultural rights is something that's going to be very exciting to watch. So I guess another challenge with the implementation of the Act is, and again, I hear this from various people, that, oh, look, it's just a toothless tiger, and that the parliamentary committees and indeed the courts are really just paying lip service to human rights. And I think in some cases you could well make a solid argument that that is in fact occurring. And, you know, if you read our annual report, I have made the comment about parliamentary committees needing to move beyond just lip service to human rights into meaningful engagement in order to build a robust human rights culture in Queensland. But this is again where I want to say that, and we've already seen this through your leadership in this project, that there's a real opportunity for you yourselves to take a leading role in developing Queensland's human rights culture and just implementing it yourself. So it reminds me of when I was a lawyer doing native title work. I would routinely say to native title holders, look, don't wait for the native title determination to go and exercise your rights. Just go out and do it. Whatever it is you want to do, just go and do it. You are the holder of those rights. You don't need to wait for a court to actually make that determination. And in a similar way, I would advocate that people agitate for the exercise and protection of human rights. Don't wait for others to do it and for the courts to say or reach a particular determination. People can take steps every day to recognise and protect human rights, and that will go a long way to building the culture that we need. And I guess the other thing I would say to that assertion that there's, the Act is a toothless tiger is that the Act does provide, and this is unique to Queensland, a complaint mechanism, so that if someone feels that their human rights have been unjustifiably limited, they are able to make a complaint to our commission, and we will conduct an investigation of the complaint. If it's appropriate, we'll hold a conciliation hearing and try to get agreement between the complainant and the public entity. If no agreement is reached, then it is true that the complainant can't then proceed to a court. However, the Commission can publish a report including recommendations on the steps that we think that the public entity should take in order to act compatibly with human rights. So that is, I don't think, a widely understood option. We've only had 2 scenarios where it's been appropriate for us to actually publish such a report. One was in relation to hotel quarantine arrangements during the early days of the pandemic. But I do think that that is an area that advocates really should take a close look at, because I think there is potential for systemic reform and systemic change to result from that complaint mechanism. There is, of course, also the ability of complainants, where they have some other cause of action, to piggyback their human rights argument on top of it. And the most likely cause of action is a discrimination complaint. And we are seeing several cases come through now where human rights arguments are being piggybacked onto those discrimination complaints. And slowly over time, we will see some human rights jurisprudence start emerging in Queensland. We've already had a couple of Supreme Court cases that have recognised human rights and sort of fleshed out what is required in giving proper consideration of human rights when making decisions. And I know that's something that Monica has touched upon in the video and just mentioned before. And I guess that is a regular question that I receive is, well, what does proper consideration mean, and how much do we actually have to consider human rights when we're making decisions? And really, it does come down to the circumstances and the gravity of the decision that's being made. So the greater the impact that the decision will have on a individual, then the greater the expectation will be as to the level of consideration being given to human rights. And really, this is the value of the Human Rights Act, is at that decision-making stage, requiring decision makers to actually turn their mind to the circumstances of the people affected by their decisions. And really, it is about empathetic decision making. And I heard Monica talk about other decision making frameworks, trauma-informed decision making. I've also seen decision making frameworks around people who have lost capacity, and the elaborate frameworks that have been developed for people who require support in making decisions because they lack legal capacity. And the human rights framework, I'm really pleased to say, fits really neatly with those other frameworks. So it is true that whilst you can't just say, oh, look, I'm following a person-centered approach and expect that you're going to meet the obligations of the Human Rights Act, I do think there is still a substantial overlap, and there's a great symmetry, I guess, with those processes and the human rights analysis process. So Monica's just appeared on my screen, which I'm figuring means I've probably come close to the edge of my time, which is useful because I've probably run out of things to say. But I'm happy to answer any questions that you have, and look forward to seeing your fantastic work continue into the future. Thank you.
Is so terrific. Thank you very much for sharing your wisdom and expertise, Scott. And we have had some really good questions come through the chat as you've been talking. And thank you, everybody in the audience. Keep that discussion rolling. It's really terrific. So part of what we wanted to achieve today was also some future casting. This is the end of this particular project, the end of a journey, but just the beginning. So obviously that conversation about human rights needs to kick into a new phase as we get a little bit more of a consolidation and maturation with the legislation. A question that came through before the event in various different ways went to the really tricky issue of the housing crisis that we face in Queensland. So we have a compounding situation that we're all aware of, obviously the cost of living and affordable housing, but also housing supply. So Scott, if you have any comments you think you can make about how the human rights legislation can address the sort of the wicked problem of a lack of housing, that would be really great.
Yeah, so you know, the longer I spend in this role, the more I come to appreciate that the responsibility of independent commissions such as ours is really to wrangle government into taking a longer term look at issues and problems. And you know, governments are so beset by, you know, the issue of the day and the 24-hour cycle, but also, you know, the political cycle. And it is fortunate that in Queensland we've moved to 4-year terms, which helps a bit. But at the end of the day, so many of our issues that I have to grapple with as Human Rights Commissioner really go back to stable housing. And I'm sure, as all of you are all aware, just how fundamentally important stable housing is for a person to be able to enjoy the rest of their human rights. So a Human Rights Act can help in the arguments that are required for governments to pull those huge, the big systemic levers. And so one that I'm working on at the moment and trying to do as much as the Commission can to support Aboriginal and Torres Strait Islander communities is the Closing the Gap process. So there are various targets that the government has committed to achieve by 2031, including housing targets. And Brisbane and Queensland are hosting the Olympics in 2032. So in all of my advocacy within government, I'm trying to say to them, use this as an opportunity to actually leave a bigger legacy than just a stadium. Look at the social infrastructure that's in place in Queensland and that is needed, and have a think about what it's going to look like in 2032 if we are unable to actually meet those targets, the Closing the Gap targets in 2031. What is the story that Aboriginal and Torres Strait Islander people in Australia and Queensland specifically are going to be telling the world in 2032 if we haven't met those targets? And the flip side of that is they could be telling a great story if we just, you know, got our act together and laid out a long-term plan matched by serious investment. Because obviously provision of housing requires that, but it is not just about the dollars, it's about the way that it's done. And the first step obviously is creating a genuine power sharing relationship with the Aboriginal and Torres Strait Islander community of Queensland, so that there is meaningful and real co-design of policy at a statewide level that is then matched by community ownership of what is going on locally. And I think that's where your organisations can play such an important role in engaging in those local processes if and when they start to materialise under the Closing the Gap process. So it's a huge question. There's no simple answer, but the Act helps with those big picture arguments and also the day-to-day, you know, arguments that occur on the ground. And the thing that I love about your project is that it's hopefully equipped people with the confidence to feel like they can use human rights language, make those arguments without having to be a lawyer or an academic. You know, they can just apply it to day-to-day situations to advocate for people to
Yeah.
get outcomes.
Yeah, fantastic. No, and I think that place-based sentiment that you talked about is what our community organisations all know is really kind of where it's at. So in the chat, we did have some comments come through, really echoing what you said about, these are your rights, take them, act on them, don't wait for government to grant them to you. But the flip side of that for Aboriginal and Torres Strait Islander peoples is a question that came through about the wicked problem of institutional racism and distrust of government. So how do you propose that Indigenous Australians fight for their rights in housing in a context where that distrust of government, will it actually change anything, is really so real for people?
Yeah, look, and it's totally valid question. Just as a bit of a side issue, dealing with that systemic racism, the Commission in the recent past has worked with the Aboriginal Torres Strait Islander Health Peak Quake on a project that deals with systemic racism in health, and it has led to some new laws that have resulted in some pretty exciting changes in health. So hospital and health services being required in law to have Indigenous representation and to develop Indigenous specific strategic plans. The appointment of Haylene Grogan as the Aboriginal and Torres Strait Islander Chief Health Officer, which has had a huge impact that I've seen already. So I don't see why similar things can't happen in other agencies. And my commission at the moment is currently doing a review of the Anti-Discrimination Act, and we'll be finalising that in the next few months. But one of the things that's come through very strongly in the consultations about that is, first of all, the impact of discrimination on people. So the psychological and material impact. I think there's much greater understanding and awareness of that in today's society than there was when the Act was first introduced 30 years ago. I think the second thing that's come through really strongly is that a complaint-based model, just relying on that to eliminate discrimination, is quite unrealistic, and that we need to move to a model where there's a positive duty imposed on organisations to take steps to eliminate discrimination, and for greater regulation of that doesn't rely on victims of discrimination making complaints, because we know that there are huge barriers to Aboriginal and Torres Strait Islander people actually making a complaint to the Commission. That is something that I've been very keen on working on within the Commission since I started, and we've had a project called the Whole of Commission Experience Project. It's been specifically addressing how we can improve our processes to make them more culturally safe for complainants. And I'm really pleased to say we've had some success already on that front, because 10% of our human rights complaints are currently coming from Indigenous complainants. So that's promising, but there's just so much more to do to ensure that Aboriginal and Torres Strait Islander people don't face discrimination in a multitude of areas.
Yeah, but some really positive steps in the right direction, which is so encouraging. And yeah, commend the Commission for its work in that way. One thing that our project really uncovered was the benefit of the human rights legislation in that service collaboration setting. And that's also, I think, a little bit about intersectionality and people have complex needs, but also multiple identities, and the human rights framework that is premised on human rights being indivisible, inalienable, and that they can't be sort of separated one from the other. And it's when all of them are realised that the protection and the fulfilment really happens. Be keen to hear any thoughts you have to share about what you've observed with a whole of government approach with the legislation, and if conversations and policies are starting to move in a bit more of a holistic way. Are we going to be breaking down silos anytime soon?
It's a good question, Monica. I'd love to say that, yeah, I've seen it. But to be honest, it's pretty rare. It's one of the great challenges for government is this siloed approach. I think because I guess one way that the Act could help is because there are 23 different rights involved and they do cut across multiple agencies. That is one way of, having different agencies respond to something rather than just one. But really that coordination of effort, I think, is a real weakness within government. And I think the closing the gap exercise again is a example of where you've got 16, 17 targets right across government and one agency trying to coordinate all these other agencies to achieve those targets. And really, I think if it's going to be successful, that coordinating agency needs to be given a lot of resources and also a lot of clout, frankly. So, in a perfect world, there'd probably be the Department of Premier and Cabinet would play a stronger coordination role in some of these key issues, and have more coordination resources to do that. But I don't want to sound negative, but that's probably one of the biggest challenges I think government faces is breaking down the silos.
Yeah, indeed. Listen, thank you so much to everybody on the line for those questions and comments. I'm now going to hand back to Sally to close out the session and thank the Commissioner.
Thanks, Mon. Appreciate it. And a huge thank you to you, Scott. We really appreciate your time and especially your candour. I think we've all been very blessed with having you here to speak so freely and openly to us all. And it's really reassuring to hear your words and talk about our sector. And hopefully, because I think through the life of this project, we have seen times where we've seen service collaboration and the human rights discussions between services actually start to help, move towards that more collaborative approach with everyone having that shared obligation to focus on outcomes for people and their rights. That sharing of obligation has just, starting to make inroads. So again, we'll get the community services to show the way through and it's as we hope it to be, But yeah, a huge thank you, Scott, for your time, and we will let you get on with your very busy day.
Thank you, everyone, and best of luck.
Thank you.
Yep. And a huge and sincere thank you also to our lovely audience here and others that couldn't join us live today but might watch again later online, those who were involved in the project and participated throughout. We just want to survey you all one last time just to see how our session went today, and we'd like to leave you with a few thoughts and comments. I'm going to paraphrase. We're into paraphrasing today, but I'm going to paraphrase one of our great human rights champions that we got the opportunity to work with through the project. They very rightly, and as we agree. They acknowledge that the Human Rights Act doesn't solve all the issues that we're facing, delivering housing and homelessness services. And we haven't found one thing that will. It's that collaborative approach that we're talking about that can really make a difference. But what it did do, and what they noticed it did for their staff, was to really support them to make good decisions, to ensure that decisions stayed focused on people and on their lives. And also the Act really helped people focus on helping, which is why they all came to do this work in the first place. So we've seen some really great value in the Human Rights Act, supporting staff in doing their work the way that they actually wanted to do their work. But we're going to leave you now with the last word from our champion organisations, and you can hear from them through their testimonial video. So we will bid you a good day and thank you all for your time. I think there might just be a momentary lapse as we move to the video. Thanks.
Very, very excited that we've got a Human Rights Act in Queensland. It's been a long time coming, and given the jurisdiction that this is, it's particularly exciting.
At the start of this journey, I didn't even know what the expectations were. I just knew that there was this legislation that we really had to come on board with.
We're often time poor and it feels like something extra you've got to do. Another thing that you have to add to your staff members, it's actually not, you're actually helping them by giving them tools to help them do their jobs better.
It's actually been a godsend, given them a tool to absolve themselves of some of that responsibility where they're holding themselves absolutely accountable for what happens to the people that are standing in front of them.
Particularly when you're trying to work with tenancy sustainment where someone might have young children in the house and you know that if you fail, that you could actually be having lifelong impacts to that family unit.
Nearly every homeless person that we would encounter is experiencing a violation of one or more of their rights under the Act. We need to make a lot of choices around what is the most just thing to do in an unjust system.
Taking a human rights lens on this is really paramount, making sure that if tenants have health and education connections in their local communities, that we consider that.
What it meant and the changes that had been made, we came to realise that individually as workers and wholly as an organisation, we have actually been working from a person-centred and human rights focus. It's just never had some boundaries or some guidelines around it. There's never been a framework for it.
It lets us hit the pause button and say, well, this is what we can do, and this is what we have done, this is what we should do in this instance.
Reconfirms everything that we're doing to be able to support women and children to have a safe and a good life.
I would love to see our sector have a consistent response or approach to how our staff, our clients and our community understand the rights.
The Act's got a huge role to play in housing, and housing has a huge role to play in the enjoyment of other human rights.
A solid, justifiable decision-making tool for them so that they can sort of say, well, look, I absolutely considered every possibility for this family.
It could be more about raising the questions and being curious. It'll be really useful when we go outside of SHAC that we will have the right language so that it leads to something positive.
So when organisations are making strategic decisions, they often think of finances and they think of reputation and do we have the human resources to deliver this? But the human rights side of things is actually really important because it will underpin the whole strategy and whether it be effective and successful.
To reinforce that change around human rights, if we can see that someone is clearly not having their rights met, how do we advocate? How do we have a discussion about what you can do? If our staff are informed, then we can inform our clients.
It makes decision makers actually look at alternative ways of doing things that are going to be less impactful on the person. That's really where the Act does its heavy lifting, shifting the culture towards a human rights-based culture.
It's more to work with since this Act has come into our jurisdiction than before. It seems to make it more real in Queensland on a day-by-day basis.
A tool that takes into account at which point of the decision making we will be potentially enhancing or limiting somebody's human rights based on the decision that we're about to make.